Hello viewers, let us understand what is mediation. We need to understand this concept. Alternate dispute resolution method of resolving the disputes is gaining momentum in India. The mediation process in India is not a newly invented procedure for dispute redressal. It is an age-old process since Vedic period. Mediation is beneficial for both the sides. The courts are being a bit less burdened with cases and the parties are getting their issues resolved quickly with less hassles and in a smoother way. As such, there has been made an important position for mediation in Indian law. With changing times, an increasing number of people are resorting to alternative methods of dispute resolution such as arbitration, conciliation, judicial settlement, including Lok Adalat and mediation in order to resolve their issues. Now, what is mediation? Mediation in India is a voluntary process where the disputing people decide to mutually find a solution to their legal problem by entering into a written contract and appointing a mediator. The decision-making powers remain with the disputing parties, with the mediator acting as a buffer to bring them to an understanding. Mediation is low cost, keeping the matters, especially family matters, secret among the parties and the mediator. Moreover, the solution is not imposed on any party. It is a solution that both the parties agree to. It thus gives an effective solution in a peaceful manner. The mediation law in India has been made user-friendly and pretty flexible. Mediation in India is divided into two categories: court-referred mediation and private mediation. In court-referred mediation, the court may refer a pending case for mediation in India under Section 89 of the Code of Civil Procedure 1908. This type of mediation is frequently used in matrimonial disputes, particularly divorce cases. As soon as a case is filed, the parties are provided with a number of ADR options, out of which they must select and pursue one, unless exempted by the court. Under court-annexed mediation, the mediation services are provided by the court as part of the judicial system. The court maintains a list of skilled and experienced mediators who are available to the parties. The court appoints a mediator and sets a date by when the mediation must be completed. The results of the mediation are confidential and any agreement reached is enforceable as a judgment of the court. Under court-referred mediation, the court merely refers the matter to a mediator. Then there is private mediation, where qualified personnel work as mediators on a fixed fee basis. Anyone from courts to the general public to corporates as well as the government sector can appoint mediators to resolve their dispute through mediation. Recourse may also be taken to private mediation in pending cases or pre-litigating disputes. What are the laws governing mediation in India? Mediation first came to be legally recognized as a method of dispute resolution in the Industrial Disputes Act 1947. In 1999, the Code of Civil Procedure Amendment Act was passed by the Parliament. It provided for Section 89 of the Code of Civil Procedure 1908, which allowed the courts to refer to alternative dispute resolution methods to settle pending disputes. Under this, the court could refer cases for arbitration, conciliation, judicial settlement through Lok Adalat, or mediation. Moreover, the Civil Procedure Mediation Rules 2003 provide for mandatory mediation. These allow the court to refer cases for mediation even when the parties are not ready for reference for mediation if there is an element of settlement. Now, which type of cases are suited for ADR? All cases relating to trade, commerce, and contracts, including disputes arising out of contracts, including all money suits, disputes relating to specific performance, disputes between suppliers and customers, disputes between bankers and customers, disputes between developers, builders and customers, disputes between landlords and tenant, licensor and licensee, disputes between insurer and insured. Then all cases arising from strained or soured relationships, including disputes relating to matrimonial causes, maintenance, custody of children, disputes relating to partition or division among family members, co-personers, co-owners, and disputes relating to the partnership among partners. Then again, all cases where there is a need for continuation of the pre-existing relationship in spite of the disputes, including disputes between neighbors, that is easementary rights, encroachments, nuisance, then disputes between employers and employees, again disputes among members of societies, associations, apartment owners, all cases relating to tortious liability, including claims for compensation in motor accident and other accidents, and all consumer disputes, including disputes where a trader, supplier, manufacturer, service provider is keen to maintain his business professional reputation and credibility or product popularity. The suitability or unsuitability of the case for reference to mediation is not exhaustive or rigid. They are illustrative, which can be subjected to just exceptions or addition by the court. Tribunals exercising its jurisdiction in referring a dispute case to an ADR process. The following categories of cases are normally considered unsuitable for ADR process. They are representative suits under Order 1 Rule 8 of Civil Procedure Code, which involve public interest or interest of numerous persons who are not parties before the court. Disputes relating to election to public offices. Cases involving grant of authority by the court after inquiry, as for example, suits for grant of probate or letters of administration. Then cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, etc. Then cases requiring protection of courts, as for example, claims against minors, deities, and mentally challenged, and suits for declaration of title against the government. Cases involving prosecution for criminal offences. These cannot be sent for ADR. I'm sure you would like to know what are the steps in mediation process in court and before the mediator. There is convening the mediation process, that is, reference to ADR by the court, preparation for mediation, and then the referral order. What is this referral order? Well, the referral order issued by the referral judge initiates the process of mediation and is the foundation of a court-referred mediation. An ideal referral order contains details like name of the referral judge, the case number, name of the parties, date and year of institution of the case, stage of trial, nature of dispute, the statutory provision under which the reference is made, next date of hearing before the referral court, whether the parties have consented for mediation, the name of the institution or mediator to whom the case is referred for mediation, the date and the time for the parties to report before the mediator, the time limit for completing the mediation, quantum of fee remuneration if payable, and contact address and telephone number of the parties and their advocates. How does the process begin before the mediator? Well, the mediator gives an introduction with the qualifications, establishes his neutrality and reposes faith in the mediation process, and the mediator requests the parties to introduce themselves, attempts to develop a rapport with them and gain their confidence and trust. The motive is to create a constructive environment conducive to negotiations and motivate the parties for an amicable resolution of disputes. There is no standard set of rules that have to be followed, making the mediation procedure flexible. The mediator's opening statement is intended to explain to the parties the concepts, processes, and stages of mediation, the role of the mediator, advocates, and parties, and the advantages and ground rules of mediation. The mediator confirms that the parties have understood the process and gives them the opportunity to get any doubts clarified. Statements are also sought from the negotiators. The parties articulate their positions, enabling the other party to understand what they want. This is followed by a restatement of the problem by the mediator, where an attempt is made to incorporate the different perspectives. Settling the agenda is an important duty imparted on the mediator in order to shed clarity on the mediation proceedings and remove vagueness. The purpose of the joint session is to gather information. The mediator provides an opportunity for the parties to hear and understand each other's perspectives, relationships, and feelings. The separate sessions are meant for the mediator to understand the dispute at a deeper level. It provides the parties with a forum to further vent their feelings and disclose confidential information they do not wish to share with other parties. Now, by helping parties to understand the reality of their situation and give up rigid positions, the mediator creates a creative option for settlement. The parties negotiate through the mediator until a solution mutually acceptable to all the parties involved. The mediator directs the parties to a solution which he believes will satisfy the underlying interests of the parties. Once the terms of the settlement have been agreed to, the parties are reassembled. Then the mediator orally confirms the terms of the settlement as a procedural requirement. The parties, with the mediator's aid, write down the terms of the settlement and sign the agreement. The settlement has the binding nature of a contract and is enforceable in a court of law. In case there is no settlement between the parties, then the case is returned to the referral court stating failure to settle. The proceedings of the mediation are kept confidential and cannot be revealed even to the court. A settlement is reached by helping parties to understand the reality of the situation and give up rigid positions. The mediator creates creative options for settlement. The mediator can conduct as many separate sessions as necessary and may even conduct sessions with groups on the same side with diverging interests. Then finally is the closing. Here there is no fixed procedure that must be followed. Once the terms of settlement have been agreed to, the parties are reassembled. The mediator orally confirms the terms of settlement as a procedural requirement. The parties, with the mediator's aid, write down the terms of settlement and sign the agreement. The settlement has been binding nature of a contract and is enforceable in a court of law. In his closing comment, the mediator thanks the parties for their help and participation in the mediation process. In case no settlement is reached between the parties, the case is returned to the referral court stating failure to settle. The proceedings of the mediation are kept confidential and cannot be revealed even to the court. What are the advantages now of mediation and why do we need it? Mediation is a better and more lucrative alternative to the court system as it gives the parties control over the scope of the mediation in terms of the issues discussed and its outcome with regard to the terms of the settlement and to settle or not. It is consent based as it allows any party to opt out at a stage if they find mediation to be unhelpful. Mediation facilitates participation. It allows the parties to directly participate in the negotiation and present the case in their own perspective. It is also economical. Mediation takes less time to resolve disputes than standard legal channels. While courts may take months or years to pronounce judgments in cases, mediations take mere hours. The mediation process can take a maximum of 60 days. The average time taken to settle a case is a mere 2 hours. If a settlement is reached, the parties also save money on their hourly costs and no further litigation. Court fees are also refunded. Since it takes less time, it is speedy, economical, and efficient. As a neutral, impartial, and independent third party, mediators ensure that the mediation remains a fair process. They also guide the parties through the process as a natural facilitator, encourage creativity in resolution, and broaden the range of solutions. Mediation promotes finality in dispute resolution as there is no scope for an appeal, a revision, or further litigation on the successful conclusion of a mediation. Court-referred mediation also allows for a refund of court fees in case of settlement. A mediation is also less emotionally stressful than a trial might be. Now, what are the disadvantages of mediation? In the formal setting of a mediation, there are no formal rules or procedures that have to be followed. Thus, mediators do not have access to a lot of tools to get people to testify or produce evidence to get to the truth of a matter. Moreover, the lack of formal rules means that there is no way to ensure a fair procedure for the parties involved. An aggressive party might be able to steamroll a timid one despite the best efforts of the mediator. Mediation may also be unsuccessful and not lead to a settlement between the parties involved. The parties will then have to resort to the money and time-intensive court system after already wasting a significant amount of time in the mediation. The agreement reached in a mediation is non-binding. Parties to a settlement may also attempt to dispute the settlement agreement in case the agreement is not made binding on them. They can file another suit in court challenging the legitimacy of the settlement, creating another dispute on top of the underlying one. The only solution to this is to agree to make the settlement agreement binding on both parties before signing it. The success of a mediation depends highly on the parties present at the table. Any mediation requires a person who can make a binding decision to be present. Parties may also want their technical experts to be present. Now, what is the lawyer's role in mediation? Clients going into the ADR process need and expect their lawyer to understand the dynamics of conflict and the process itself. With the constant pace of change in legislative environment, in common law, lawyers are required to prepare their clients for mediation. Despite the increasing use of mediation as the most popular form of ADR process, many lawyers are not prepared for what actually happens in a mediation session. They often appear to have no overall plan of their case, have not prepared their client properly, and have no understanding of the other party's point of view. This impacts in a negative way on the mediation process to reduce and de-escalate the conflict. Some lawyers see their role in mediation as quite limited. They explain the process to the client, may make the opening statement, provide legal advice, and then throw their clients into the process without any lifeline. Others try to dominate the process. They behave in an adversarial manner as if they were on trial and often limit or prevent their clients' participation in the process. This is unfortunate as the lawyer has a central role and, in some jurisdictions, a court-bound responsibility in making mediation work for their client in a constructive, creative, and productive way. As in litigation, preparing the client is the most important step by the advocate. If the client can speak well, then let him or her interact with the mediator and the other side directly. A well-prepared client does not need to be protected by themselves and in the mediation system has full confidentiality to protect them from statements that may hinder litigation, but are helpful in working towards resolution in the mediation process. Working with the client before the mediation helps identify the client's best alternative to a negotiated agreement. That's BATNA in short. Further, the client will be able to understand the worst alternative to a negotiated agreement, that is again VATNA in short, which will help the client to better work towards problem solving the issue. This allows the lawyer to work with the client to better decide what the parameters of a negotiated agreement should be. We need to be part of the solution, not part of the problem. The lawyer, as a problem solver, has the ability to analyze situations through a lens that sees both the client's and opposing party interests. By translating client positions into interest, generating and assessing conventional and novel options to address the problem, counsel performs a valuable service to the client, who often cannot step back from the conflict to see the light at the end of the tunnel. Perhaps most importantly, counsel can work to build consensus around an option which best addresses the goals and interests of a client or the parties involved. Can the mediation agreement be challenged? A successful mediation results in a negotiated agreement that takes the place of a contract between the parties. The parties cannot pursue any litigation for the underlying dispute if they are dissatisfied with the settlement reached, as it would amount to a breach of the contract. However, if the parties wish to dispute the agreement, they can bring an action in court challenging the validity of the agreement based on the principles of contract law and not on the basis of the underlying dispute. So viewers, what I would like to say is that we should think of the 3 M's, that is mediation, meditation and music, because all the 3 give us peace. Music gives us peace, meditation gives us peace, and mediation also gives us peace. And with these 3 M's, we can have a stress-free and a happy life.